Good afternoon, viewers, and wish you a very happy new year. 2015 has gone and we are into 2016. My name is Amitabh Singh, and I am the moderator for today's webcast. This webcast is organized by on behalf of IFA-India Academy, and we'll have a discussion on international tax and transfer pricing developments in the last few months. As you may already know, that IFA India Academy is a premier knowledge sharing platform for uh, international tax and transfer pricing, and it regularly holds classroom sessions as well as seminars and conferences on the subject at its facility in Noida as well as in the NCR. In today's episode, we have our two distinguished tax experts with me, and I will, without further ado, introduce them. To my right is Mr. Ajay Vohra. Ajay, as you know, is the managing partner, former managing partner, just to be correct, of Vash Associates and a senior advocate. And facing me is Mr. Mukesh Butani. Mukesh is the non-executive chairman of BMR Legal and its managing partner. So I welcome Ajay and Mukesh. Wish you a very happy new year to you too. And thanks for taking your time out for doing this webcast. 2015 has been a very eventful year as far as international tax is concerned. We had the BEPS final report. We had the black money bill. The government took a lot of measures to reduce tax litigation, increase transparency, and some of those are what's featured in today's discussion. So we'll take the first topic with your permission, which is the draft OM guidelines, which was issued by the CBDT, Place of Effective Management Guiding Principles. It was being awaited for a long time. The law came into force with effect from 1st April 2015, I guess, if I take the previous year into consideration. So it's running. The effect of this law is running. The guidelines were actually issued on 23rd December 2015, and the consultation was asked for. Public comments were invited, with the final day being 2nd of January 2016. Did it throw a spanner on your holiday plans with such a short timeline? Any of you?
Not really. I was here. I was not taking a holiday, so I don't think it disrupted any plans of mine.
Oh, well, fortunately for me, I will also didn't take any time off, but I read it and it was good to read it. I had a nice laugh about it.
Nice laugh. Okay, so that's my cue to put the question with you that having read the guidelines, I'm sure some comments would have gone from your firm to the department. What's your overall view of it? Your concerns and any positive things that you see out of the whole thing?
Well, I'll give you my personal views because sometimes individual views are different than the views expressed by the organization. Before we get to the guidelines, I have a fundamental issue with the entire law itself, the place of effective management, because I feel that to legislate a law and call it as a law to deal with tax avoidance is in itself a flawed argument, because really internationally the place of effective management rules are nothing but tiebreaker rules under the OECD Model Convention, Article 4, which says that if you cannot determine the residence of a company using the criteria of domicile, residence, place of management, or any other similar criteria, then you really look at resident being the company being resident where the place of management. So first point. Second, it deals with a treaty situation where two states are trying to decide which state will the space of management reside. And it's also possible that the domestic laws of both the treaty countries say that the place of management is in both the countries. In that situation, treaty says that, well, in that case, we'll decide the issue of economic double non-taxation. we have a domestic law on place of effective management, and that domestic law is anti-avoidance law. And amongst the whole set of detailed guidelines, one of the most important pieces is that if the place of effective management is in two states, it will be deemed place of effective management to be in India,
Yeah,
which
presumed.
which
Yeah.
means that it's just straight away overrides the treaty. I do not know how the question of economic double taxation will be decided. So my fundamental disagreement arises from number one, why is this law legislated? What is the purpose of this law internationally? And then if I look at the rules, even if I accept it, passed by the parliament, so we have to
Mhm.
accept it respectfully. And if you have to accept it respectfully, then I think the draft guidelines have come to me as a bit of a disappointment, because what do you now go and tell the clients that if you have a situation where place of effective management is in two countries, it will be deemed that it is there in India. I think that's very unfair.
Is that your view, Ajay?
Yeah, I would also echo what Mukesh has said, that actually it leaves many unanswered questions. You see, for instance, where the double tax treaty comes into operation, how
Mhm.
will you read these guidelines relating to place of effective management as part of the treaty? Both the treaty countries may have different rules relating to determining the place of effective management.
Right.
So I think in those kind of situations, the conflict is definitely bound to arise.
Mhm.
Then, secondly, where you deem the place of effective management, there can be instances. For instance, these are completely unintended.
Mhm.
Now, one question that comes to mind is, will that company be required to pay a dividend distribution tax? You deem a Mauritius-based company to be resident in India,
Right.
right? And it
Right.
declares dividend.
Right.
Now, is it required to pay dividend distribution tax? Now, these are ancillary questions because
Right.
the DDT, somebody will say, is applicable only to a domestic company.
Mhm.
So, does it become a domestic company? Can somebody say that, like for instance, in the earlier time, you had 80HHC applicable only to resident
That's
companies?
right. Right.
So, can similar such incentives available to a resident be claimed by such an entity? Will you carry this to its logical conclusion?
Mhm.
Will, for all intents and purposes, be treated as a resident company under the Act? So these I don't think have really been thought through when you
Mhm.
seek to deem this as a resident company only for purposes of tax avoidance.
Right. So if you're having a transaction with that company, will it come under transfer pricing, for example?
These are open questions, and I don't put it beyond the revenue to raise this. Some overzealous officer can certainly look into it and say, like, look, you are deemed to be a resident company, so
Mhm.
therefore these are the consequences that follow.
That's right.
Yeah.
So, Mukesh, coming back to the guidelines, they are, it's like a fait accompli
Yeah.
on it, and unless your vociferous, protestation allows its withdrawal or a substantial remake. Coming to the way the guideline has been drafted, it starts with an active business test. Uh, and before that, as almost as a preamble, they say that it's an international. I have never seen in place of effective management the active business test ever coming into play. So,
Correct.
what do you think spurred that kind of logic?
So actually, if you look at the main part of the law, it's aligned. I actually tried to plot how this law has evolved over Direct Taxes Code Bill of 2009, then Direct Taxes Code Bill of 2010, then Direct Taxes Code Bill of 2013, and then what the law says. The first bill said poem at any time in the year is situated wholly or partly in India. No definition. The second time in 2010, it says poem at any time in the year is in India, and then they have said what defines poem. But there has been consistency with definition insofar as Article 4 is concerned. Actually, every the place where the key management and commercial decisions that are necessary for the conduct of the entity's business as a whole are in substance made. The only difference is that the Indian law says for the conduct of the business of an entity as a whole are in substance made.
Mhm.
Otherwise, there is no difference. I think the challenge is that are you using this law to determine poem in the context of a conflict of treaty, or are you using this law as an anti-abuse? I think the income tax law, the way it has been worded, it is the latter.
Mhm.
That is the reason now you go into the definitional aspect of principal purpose test, so on and so forth. So I think the law is going to create several challenges at a practical level if it is implemented in the manner in which it is written, insofar as taxability of Indian companies is concerned, sorry, offshore subsidiaries of Indian companies are concerned,
Mhm.
because you will have situations in which people who are sitting in India are taking management decision, and hence the whether the effective management is situated in India or outside India becomes a contentious issues. Uh, Even if I accept these regulations in its entirety, I would have said that because India has a wide network of treaties, least they could have done
Mhm.
is say that in the event two states, including India, are trying to take a position that place of effective management is lying in India, then the competent authorities will try and resolve the situation. I think this creates, in my view, an extremely incongruous kind of situation, clearly leading to economic double taxation. And I don't know what is tax evasion about it. The only part of tax evasion I can think of is individuals or companies that are based in India and residents in India, they set up offshore subsidiaries which are really paper companies. And these paper companies go and transact business or go and own real estate, derive income out of that. In my view, those are clearly abusive provisions. The question that we should ask ourselves is, do we need a law of this nature to be able to deal with those abusive situations, because we have several provisions in the income tax law to deal with those abusive provisions. And if you don't have anything specific to the test of residence under section 6,
Mhm.
then we could have waited for GAR and incorporated these abusive forms of techniques within the ambit of GAR.
No, Ajay, like Mukesh said, if it was meant to target these kind of passive shell companies, couldn't something like a CFC legislation be the more effective tool?
I would tend to think so. This will become all pervasive, and it is bound to lead to litigation. You see, the issue, as Mukesh put it, you could make an amendment in Section 6 itself to say that instead today of saying that the management and control is wholly outside India,
Right.
you could have said is partly outside India. Now,
Right.
and then when you define this place of effective management, you would have had to leave it to the internationally accepted principles.
Right.
We have in Section 6, in any case, the test when you talk of place of management as where the head and brain resides.
That's right.
You already have judicial precedents which say that you don't have to look ordinary day-to-day functioning happens, but
That's right.
where the key decisions are taken or policy is decided.
Mhm.
Now, those are already well settled, well defined judicial parameters.
Mhm.
And I would have thought that that would have served the purpose if you only tweaked to
Mhm.
say that wholly outside India to mean partly in India or partly outside India.
So, do you think the government, in its noble purpose, to in its aim to reduce litigation, wanted to come up with some clear guidelines? They have actually sort of taken a big step in this direction.
You see, I would think that the guidelines leave a lot of room for subjectivity.
They
It's a
still do.
matter of how you implement the guidelines.
Mhm.
Now, this is the active versus passive business is purely an arithmetical test, but that test can also lead to different results on depending on how you interpret. I'll give you the example of explanation to Section 73 when you define whether it is speculation business or not. You
Mhm.
have to exclude those companies which earn income mainly from capital gains, house property, and so on.
Right.
Now the test is whether you will apply the asset test or you will apply the income test.
Right.
Those are
Mhm.
again controversial issues.
Right.
Similarly, here when you talk of 50% of assets are in India or outside India, now
Mm.
there can be many variants of this situation.
Yeah, even passive income.
Yes, even passive income.
Yeah.
Somebody who's doing a business in
Mhm.
money lending, can you
Mhm.
call it passive income? He would claim that actually I'm doing business,
Right.
and this income is essentially income from business and not in the nature of passive income.
Right.
So all these issues will arise when this is sought to be implemented, and I would think that the decision reached by each assessing officer may be different on the same set of facts.
Mhm.
How he was to apply the test laid down in these poem guidelines.
So, in the guidelines, they talk about that an AO cannot unilaterally,
Yeah.
you know, come to a conclusion. He has to take approval from the principal commissioner or commissioner, and there will be a show cause. You know, all the principles
Right.
of natural justice. The question to you, Mukesh, is one: do you see that this as an effective measure? and linked to that is, of course, that as a guy, can you put these kind of statutory, almost quasi statutory things in a guideline?
I don't know whether this safeguard in the first place is adequate enough, because even today, for a transfer pricing assessment, a transfer pricing officer is supposed to be getting the order review by the senior commissioner. I mean, as I can read from the guideline, is that before he gives a finding, he has to seek a prior approval of the principal commissioner or the commissioner, and the commissioner will give an adequate opportunity. I don't know whether this safeguard is good enough. To your second point, even if this safeguard was provided for in the statute, that helps solve the purpose, because the whole idea is to provide a set of checks and balances so that these subjective guidelines, which can be onerous because it depends on the interpretation taken by individual officers, does not subject the assessee to any kind of inconvenience. So even if these were put in the statute, I don't think that's good enough. I would have ideally liked that this be examined by an independent committee or so on and so forth. So I don't think that this is good enough. I think it's entirely depending now on the officer, what calls he takes. If he gives a finding the place of effective management is in India, then you have a problem.
See, I would also say from practical experience, you have many provisions in the Act where prior approval is needed. And most of the time you find that the superior authority says, yes, I am satisfied.
Yeah.
And the courts have struck down saying that this is a mechanical approval without application of mind.
Right.
If something of this is to happen, imagine the plight of the taxpayer. In a post facto situation, 3 years after the transaction has happened, you suddenly treat the company which is incorporated outside of India as a company resident in India, with all consequences to follow. You've opened his assessment not only for that year, maybe the succeeding years that will follow.
Yeah.
So look at the chaos that will reign if this kind of dispensation is to be given 3 years post the transaction taking place. Then I understand in the India-US treaty, if both countries come to the conclusion that that entity is a resident of their respective country, the treaty will not apply.
No? The whole application of treaty falls.
Yeah. So now imagine what the taxpayer will be subjected to. He'll be subjected to double taxation in both the countries.
And no relief.
And no relief. And no relief.
And by the way, just to add to what Ajay is saying, determination of place of effective management is one part. So suppose that there is a case where a non-resident company's place of management is determined to be in India. It is resident in India. Now, how do you go about dealing with the computational provision? What if the foreign company is not an SSC in India? What if it has not complied with requirements under tax audit or statutory audit under the Companies Act? I think that none of that has been dealt with. I'm talking about the computational challenges. It's like saying I have come to a determination that there is a permanent establishment. Now, how do I go about attributing income? So I think that this law is, in my view, is a fairly unprepared state of affairs that we are in, and nowhere in the guidance it has been dealt with. It just says you're resident in India. Yeah. Now, just because a foreign company becomes resident in India, as a result of, say, place of effective management rules, you cannot obviously bring the worldwide income of this foreign company to tax. Okay. You need to go to the principle of attribution. So what is the kind of information that the officer is going to seek in order to be able to do a assessment, in a non-judgmental manner? I think those challenges are going to be staring at us now that this law is already in operation.
Absolutely.
So if I were to, ask you, that where is the flaw? The flaw was in the initial amendment to section 6.3, or is it in the guideline? If
See, I would think that you can't possibly provide a guideline which will cover all situations.
Right.
So if you provide guidelines which are not well thought out, because in the sense it cannot, look at all conceivable situations that can arise, then in that situation it leaves a lot to imagination of individual officers.
So as far as the law was written, you think that is fine, that is right. That is doable. Do you agree?
I have a slightly different view. I read out the trend of this form of law. First time when it was introduced in the direct taxes code until the last draft of 2010, this was a CFC law.
CFC, yeah.
So the CFC law merely provided that certain forms of passive income will be taxed under certain circumstances, but it also provided a credit mechanism. So let's assume, let's forget about Section 6 amendment. Let's assume that there's a CFC law, there's an Indian company with an offshore subsidiary and several step down subsidiaries. This offshore company is a holding company. It is sitting on all forms of passive income that it earns from other active subsidiaries. It is not remitting into India, and India wants to tax it. This mechanism was provided in the direct taxes code, what was called a CFC law. It also provided a mechanism how to claim credit of that passive income that is sitting at an offshore level. That law made some sense to me. Now, what we seem to have done is that we seem to have brought a law which looks similar, but it is fundamentally a very different law. So if today you give me a place of effective management rules that we have, and the CFC law that was thought about, and which was also observed as draconian by many analysts and many commentators, I would certainly prefer that law, because that law had a mechanism for taxing income, how the proportionate income has to be taxed, how the credit has to be taken. It was at least, there was some that law in the manner in which it was done. That doesn't seem to be the case over here. So the question that I have is that, first of all, the determination of place of effective management is vague and very, very subjective. After determination, then what do I do? So as a taxpayer, I'm asking a question. So how will you now go about computing my income? That doesn't seem to have been answered in these regulations.
So I think it is assumed that once he's a resident, the consequences will naturally follow.
Yeah. But how will that consequence follow? You see, you're not dealing with an Indian company over here.
So things like how will you serve your notice, service of documents.
What if somebody questions the jurisdiction? Is the order of, I think you asked that question earlier, is the order that you have effective management in India appealable?
Yeah.
Doesn't seem to be the case.
Yeah, if the commissioner, if he decides, can you appeal? Can you go to the higher
this
courts?
I think will become part of the process of assessment.
Okay.
Except it will be a decision of the assessing officer with the approval of the commissioner.
Sure.
But it will be certainly be appealable.
So it won't be a separate track.
No.
It won't be a separate track.
Sure.
It will basically be then an assessment on a resident company.
Okay.
Sure. So the question we should ask is, would it have been better that after determining that you have a place of effective management in India, that itself is appealable before it proceeds to do the other?
Yes, sir.
147 proceeding.
Yeah,
Where you can appeal
yeah.
an order on the jurisdiction, and then you can appeal on the merits of the case.
I think Mukesh has given a very valid, and thoughtful suggestion. This can be incorporated as part of the process, because if this very determination falls, you don't have to go through the entire mechanism of a computation. So I think the law can provide that if there is a determination by the commissioner, you file your objections to the assessing officer, there is a determination by the commissioner, they overrule your objections, that should become either appealable or subject to writ jurisdiction, so that the assessment does not have to unnecessarily proceed in the event that determination by the commissioner is finally struck down by a superior authority. Yeah, I think that is something that can be provided, because the computation itself will throw a lot of challenges. For instance, how would you compute MAT income? Suppose it becomes a resident company and thereafter you have to compute book profits. You will ask them to produce their overseas balance sheet, which may have, the consolidation, like you said, the offshore company is a holding company, let us say in Mauritius, with step down subsidiaries across. So how will you, seek to apply the MAT provisions to that company is an open question.
Sure. The other challenge that you have is Indian companies having offshore subsidiaries are structured through a complex web of, step down, 2 steps down, 4 steps down. Let's assume that 1 step down below the Indian company, it's held that this company's place of effective management is in India. Are you going to now start applying those tests down and down and down to the second layer, to the third layer, to the fourth layer? I don't know that. It's not coming out clearly from the regulations. And it may well be a case of the tax administration that you're not dealing with place of effective management at just below the Indian company level, but 3 steps
Could
below
be
the
layers
Indian
down.
Yeah, absolutely.
No,
because
this, what I get a feeling is that we are actually, it's like a Pandora's box
It is.
that we are
I
looking at.
think it is quite a Vodafone-like situation.
we're
If
sitting
you
on
ask
a
me,
time bomb, if you ask
if
me.
you ask me, it's a Vodafone-like
Mhm.
situation where you have a maze of subsidiaries.
Mhm.
Except in that case, the investment was in India. Here, you are looking at an outbound investment through a holding company structure.
But funnily enough, if I look at the sound bites, unlike GAR, where the entire corporate India was up in arms, talking about it and protesting and securing a deferral, these guidelines, apart from the professional circles that we inhabit, I haven't seen too much attention. Is it that people are missing something here?
I don't know. I feel that after the law was passed by the parliament, it was a fait accompli kind of situation. That this law is there,
Mhm.
much as it may sound draconian,
Right.
you have to accept it. Now, how much noise do you make on regulations?
And then going back 2 years, especially when the first year of its application is concerned,
Yeah.
you're actually putting a retrospective effect to it. So
Right.
after coming of this law, if somebody sort of restructured its affairs, that okay, now this point has come, let me now take stock, see that my place of effective management is actually outside India, but his history will continue to haunt him for a couple of years. Is that
Yeah.
what you feel?
See, when the law came, there was some noise when that Indian companies having subsidiaries abroad felt that they would be taxed in India. When the amendment to 6.3 happened. Now this is projected to allay fears and
Yeah,
to soothe nerves, transparent guidelines.
that's right.
So the people or the industry ended up saying that this is meant to impart transparency to the whole process. So you will not have unnecessary, adjustments being made. But nobody seems to have gone through the fine print. Nobody seems to have, realized what damage this possibly can do. So we are where nobody has gone through the fine print.
Right. The bomb, as you said, is ticking. So,
Yeah.
it'll explode the moment this year is over, I guess, when the returns get filed and the
Yeah,
first
yeah,
assessments start.
Yeah.
So the jury is out there. I'm
Yeah.
sure, you would have given very strong views to the government about this legislation or notification as it's supposed to be. So let's wait and watch what's the final shape and draft. But I think the message is clear that this is the guidelines tend to do more damage than allay taxpayers'
Sure.
fear. So let's hope for the best. Uh, Maybe on a slightly more positive note, we come to our next topic, which is the various measures that the government has taken over the last 1 year to reduce litigation. What they say is to do away with the so-called adversarial tax regime, which had been, in the press so much all these years. So if you were to, Ajay, look back at 2015, what are the key milestones that you see which comes to your top of the mind recall, which you think are laudable steps in this direction?
I think the first and foremost is circular that has enhanced the limits for filing of appeals,
Right.
and more specifically, the government clarifying that this will apply with retrospective effect. You remember earlier,
Yeah.
most courts had taken the view it will apply with retrospective effect. There were one or two dissenting views. The Supreme Court surprisingly said it does not apply to pending appeals, and they sent the matter back to the Delhi High Court. So now the government has in the circular itself not left it open to judicial interpretation, clarified that this will apply from retrospective effect. And we find it day in and day out in the tribunal, in the High Court, these matters being picked up, pulled out, and being dismissed. So that's I think a very welcome sign that you are wanting to put an end to litigation, especially where the tax effect is not very material in today's environment. There may be matters pending in courts for years together, which would have lost their relevance or are not materially significant in today's times. So I would think that that's a big positive, considering that government is the biggest litigator.
But Just on a lighter note, did it mean some loss of business for you in that sense?
I would think that we need to look at it optimistically. There are many cases in areas in the courts, many cases in the pipeline. It's just that more cases will come up front, and I don't think litigation on an overall basis is bound to reduce.
Okay.
Yes, to the tax fraternity, it may make a difference to people who practice at the lower level. There will certainly be a churning at that level. The number of cases will die down. I just want to sound a note of caution here that with these matters not going up in appeal and the limits being raised, the murmur that I hear is that the lower authorities will realize the significance that the matters are going to become final. So you know the consequences that follow. I don't need to further dwell on that.
So Mukesh, do you see this limit as reasonable, or do you think the limit should have been higher?
I think it's a good start because the limits have been, are now fairly liberally, let down, as stated in the new CBDT circular. They've retained the Supreme Court limit of 25 lakhs, but High Court and Tribunal is good. But, on a similar note, I have always felt that one of the reasons the cost of litigation, one of the reasons litigation is high in India is because the government doesn't charge user fee for litigation.
So the cost of litigating is low.
That's right. And historically, even lawyers' fees were not that expensive. But the scenario has changed in the last 10 years. The government has retained its position of charging very little as user charges, and lawyers' fees have gone up over the years. I think that the government will do well by charging higher cost. I know that this is a very unpopular suggestion I'm making, but at the end of the day, you're taking up the court's time. You're taking up expensive time of the judiciary. This will help reduce litigation. This will help reduce frivolous forms of litigation. So and the court should also not hesitate in ordering costs. I think again, conventionally, courts desire to order cost is more a token cost, more as a messaging that you got a frivolous case before us, whether it's a taxpayer or the department. I think if the court starts ordering high costs, then I think you will have more responsive litigants. And when I say more responsive, means both the government and the taxpayers. So, and I can see that the raise in the limit is a step in that direction. I will not be surprised if in the future the government starts considering raising the cost of user fee. You look at APA legislation. You have to pay up to 40 lakh rupees to get an APA. What is the government trying to do? They're trying to say that you're taking away our expensive time of senior officials who are going to give you a ruling. I think the courts should start following that philosophy as well. You will reduce a lot of frivolous forms of litigation in India. That coupled with the enhancement in, I think this is an excellent move.
Do you think it will also, improve the quality of orders? People, the members will have more time to give to the balanced litigation which is there.
I have always believed that you pick up fewer cases, follow a very scientific basis to pick up those cases. Now you have the CAS, computer aided risk assessment system. I think this will improve over a period of time, which means that the departmental officers will pick up fewer cases, spend more time on that, where they see the level of risk is high. And that's automatically going to have lesser number of assessments, fewer assessments, then fewer of those cases going into appeal. And I think it also improves the department's chances to be able to defend the orders of the lower authorities before higher appellate forum, because if you have scientifically applied the risks basis of choosing the assessment, then you're really saying that you really see some kind of a tax evasion occurring, or you really see some kind of a questionable scheme, so on and so forth. So I see that it has already started, but the benefits of this will be visible only in the short to medium term and not in the short term.
So one thing I think the circular has clarified that if the department withdraws a case, it should not have any precedential value. So could you just elaborate on that? Plus, they have talked about something about clubbing of different assessment years. the limit should not be treated as a composite limit if 3 or 4 years are taken together. So is there some technicality around that?
No, I think that was in the earlier circular where they said that you need to club to see that if there is a cascading effect. So then they said the limit will not apply.
Okay.
But now if you have 4 years together
Right.
and one of the years is below the specified limit, that 1 year will be kind of dismissed, or that appeal will become frivolous.
Okay.
Without affecting the other year's appeal. So this will not be treated as a binding precedent for the other years, nor will it amount to saying that since you did not appeal in year one, you are stopped from claiming that this issue is live in the second year. So that will not be viewed adversely against the department that they did not file an appeal in year one on ground of low tax effect.
So for someone who makes his living, fighting in the courts, you still feel this is a happy
No, I think for the country as a whole, I would think this is extremely productive.
So country before self.
Country before self. And secondly, I think there are enough cases in the system. You see, the courts are today clogged. This will declog the courts to the extent of those not materially significant cases will go out of the radar. The court is still fully occupied. Their time is still to be devoted to all the pending matters. And that will help, develop the law. That will help declare the law for the country as a whole. So I would think this is a very productive measure.
It will not encourage tax officers to make even more higher pitched assessments just to go beyond that limit.
Well, I don't know. I think if the outcome of that is officers making higher pitched assessment, then the whole purpose of this has gone down. Neither have I heard anything negative from the local bars on advocates finding themselves short of work or matters in which they would have billed the clients and now they can't because the tribunals have to dispose of the appeal. To your earlier question, there are three principles that we have to read. One is what Ajay talked about, that you have to look at each year separately. Secondly, now the circular enjoins a responsibility on the income tax official to record that even though the decision is not appealable, appeal is not being filed considering the monetary limit, which means the taxpayers can't now take the advantage of that principle of res judicata will apply and in the latter years. The important aspect is that the department's counsel now will have to make every effort to bring this to the notice of the tribunal or the court why this appeal is not being filed. So they have to record the reason.
And they have to preserve that.
And they have to preserve that. And there are a set of exceptions that have been laid down that these monetary limits will not apply where constitutional validity is being challenged, or where the board's order is being challenged, or you are challenging an issue which cannot be quantified. Let's say, for instance, rejection of books of accounts. You're challenging that. Now, you cannot now bring that under the monetary limit because you don't know what the monetary impact of that is. So I think this has been a very well.
So it's a well thought out
circular. Somebody has gone through it, looked at the past experiences and why the scheme failed in the past, and the Supreme Court sent it back to the. I think it's a fairly well thought through.
So I think Ajay's primary pick was this circular. Anything which strikes you?
Well, I think the good thing about this circular, it applies retrospectively, which means it applies to all the pending cases. So even if you had a matter, say before a tribunal which relates to assessment year 2, 3, it goes away with this circular. I think it's a very bold move, and I also feel that this will also help the government take away a lot of arrears. Because right now in their record, there are many of these areas of outstanding taxes which are there. It'll all get knocked off.
And there being no indexation. So even if it's a 10-year-old case, the present value is not to be judged on that basis.
Right. And if I'm not mistaken, this applies only one way to the government.
So
only the taxpayer is pursuing, which I think is a very fair proposition.
So that's what in the press, what grabbed headlines was that in the Rajkot bench, I think 1,500 cases were dismissed, in one shot, and I guess it would be happening in other tribunals also.
I think from taking a cue from what you said, the only anxiety that I have is that many benches of the tribunal, especially in tier 2 towns, will actually have no work. With so many appeals being knocked out, you will have members sitting idle, Now you need to rationalize those resources that they can be put to use in other benches.
In the
Correct.
more overstressed
Yeah.
jurisdictions. Yeah. Very good. So, taking the cue from the monetary limit, which came as the top of the mind recall, some of the other, let's talk about some of the other, path-breaking measures which the government has taken. In no order of importance, but let's take, the mandatory e-filing
That's right.
of appeals.
Yeah.
What do you have to
I
say
don't know.
about
I
it?
actually looked at the mandatory e-filing form, went into the system. I couldn't see any fundamental difference between that and Form 35. I think they could have made it a little bit more elaborate. For example, it's important for the government now to start building databases. Which areas are the disputes occurring? So I don't think is it occurring out of an interpretative provision, deduction under section 36, 37, a brief summary of the taxpayer. Is it occurring because of technical issues such as no evidence submitted? I think and we need to start building this right now, because today if you ask any official, any data, none of that data is available.
So
So
no
today if I
analytics can be done.
absolutely,
Yeah.
today if I have to ask, please tell me how many 80 section 80 HHC related disputes are lying at various appellate forums. It's impossible. So I think the government could have made a start by amending the Form 35 in such a manner that this data is available. I think they did the same exercise when they did the electronic return file, tax filing return, where the return form was designed in such a manner that the analytics could pull out all this data. I don't think it is there.
No, I don't. I think this form, this e-filing is mainly intended to eliminate the interface between
Reduce the
between the
paperwork.
government and the taxpayer.
Right.
We have in the Delhi High Court some courts which are e-courts. So where the entire filing is e-filing electronically done. Even the judges don't like you to submit a hard copy paper book.
Okay.
Whereas we on the other side, the judges have the huge screen before them, and they are actually dealing cases on their screen. But it will be some time before this can be implemented across. This is a huge project.
It's a huge
It's a huge project. I think, as Mukesh said, for the analytics to come into the system, it will require change in the design of the form. It will require huge hard work, hardware being put up by the government before all this can happen.
Yeah, because unlike a tax return, suppose do you upload a paper book also, or you carry that with you?
No, to the High Court we put it in a pen drive.
You put it in a pen drive.
Yeah, the judges are then able to scan it on their screens.
Right. And on Delhi High Court, it has worked very effectively.
Yeah, it has worked very effectively
because you don't see those huge files. The judges, they just have this thing.
And
but
you are
for
also
instance, this is only a couple of courts in the Delhi High Court.
Right.
I have not seen it in either the Supreme Court. I have not seen it in any other High Court.
It's not there in Bombay.
Yeah.
So it's a step in the right direction.
It's a step in the right direction, certainly.
But a lot more needs to be done, especially the analytics part, to capture the right fields and the data so that they can be further
mined to productive use.
Yes. So on the same electronic theme, there was certain very clear directions from the Revenue Secretary that more and more communication should be done via emails, and they have talked about now serving notices and other forms of communication through emails and electronic communication. What is your take on that? Does that create any legal issues, or do you think that it's something which is passed overdue?
No, I'm not sure whether our Income Tax Act recognizes the email at the moment, but it will only mean an amendment to the law saying that service through email will amount to proper service in accordance with law. But this is certainly welcome. It is to again reduce the human interface.
Yeah. So they have inserted a new rule
where
they have enabled that. So Mukesh, do you feel again that this is going to reduce that interface, which is source of all malpractices?
Yeah, as I heard, and I see this circular, I think it's a pilot project. So if you're referring to the 19th October circular, it says that steps are being taken by the CBDT to devise suitable mechanism for setting up standardized platform for all email communication. I think that's probably they are looking at how do you go about serving a 143(2), in this, which is the, I think it requires an amendment to the law clearly. But as I read it, they are saying that to start with, it has been decided to launch a pilot in 5 non-corporate charges at Delhi, Mumbai, Bangalore, Ahmedabad, and Chennai. So to me, it seems that this is like more a work in progress.
Yeah,
Yeah.
The way I gathered was that they are trying to bring in this concept of paperless
That's right.
That's right.
assessment.
That's right.
Where you
More
may
than
not,
paperless is you are not visiting the tax
yeah,
office.
you're not standing there for 2 hours
2 hours,
just to get in.
Right.
So, obviously, this is something which has been there in a lot of overseas jurisdictions.
Right.
So, I guess it will take time. The pilot will be run.
Right.
But do you see this as positive, or do you see any problems happening, or will it remain as a wishful thinking, much like what the Citizen Charter has become?
I don't know. I certainly feel that there are a lot of merits in this. I think we have to move to more electronic basis of communication in general. I also feel that given the work it involves in trying to achieve e-assessments for all the 3.5 crores taxpayer, it would be like the exercise that was initiated on electronic TDS returns. I think it took a good 4 or 5 years for that system to settle down, and there were so many niggling glitches that came up. I see that here as well. So there would be a transition period. But if you ask me, will the purpose be served from a medium to long term standpoint? No doubt about it. This will be helpful. Also, both the taxpayers and the department will get over historical issues. Whether a notice is served or not. Was it delivered or not? And taxpayers and government both have been going to the courts on these very fundamental issues. So you'll take away all those technical issues out with electronic system of communication.
I think all in all, it's a very positive move.
So you have to be watching your email servers with greater alertness.
But here also there are safeguards. It said that the pilot that has been chosen is for 100 cases, and this is the department will seek permission from the taxpayer before they make them a part of the pilot project. And I think this has been provided only to be able to make sure that there is no statutory embargo, because they clearly will have to amend the law or amend the rules to bring in the electronic assessment.
So you will be watching your junk folder in your mailbox even that keenly. If
well, I think electronic filing of many of the forms has worked very well. I don't see any reason why this should not work. The more important aspect is that this will establish a trail of communication. So you cannot then, it will be far more easier for the tribunal to verify the records. Right now the tribunal has to call for physical records. Now this will establish a trail in the future for tribunal. The SSCs and department will not get into it whether I filed this or I did not file this. Is this an evidence on record? Is it not an evidence on record? All of that will go on.
So, all in all, the e-governance initiatives that the government has been taking, paperless assessment, electronic communication, is a move in the right direction, especially for SSCs who are overseas. I think for them, physical presence is more of a burden, and they are more used to this email culture, if you can call it that. Coming to the next measure, which grabbed my attention, was the department tasking the Collegium of Commissioners to withdraw appeals which are already there with the High Court, and this is different from the monetary limit aspect. And it seems to have been spurred from some very critical observations by the courts about frivolous, casual, callous way of filing appeals. So what's your personal take on that? How far this measure do you think would be really successful?
Let's step back, Amitabh, a bit. I would think that in the past, every authority, in order to pass the buck, would move the file to the next authority. So you had invariably appeals landing up either in the tribunal or in the High Court, because the department couldn't decide whether or not to file an appeal. So that frivolous or casual filing of appeals invited this kind of comments where you may have cases where it is clearly not defensible, and yet the government has come up in appeal. Setting up this task force of Collegium of Commissioners to scrutinize the appeals that are in the court and to withdraw those which are frivolous, which are indefensible, not maintainable, I think is again a very positive step. It will declog the system. It will remove areas from the courts, because every time a file comes to the court, if you sit in the High Court or in the Supreme Court, look at the movement of the file from the time it is filed, movement to the registry to the Supreme Court or to the High Court uh, for hearing in the High Court. At least valuable time is lost in the whole process. Now, if you withdraw the appeal, you are actually saving that process for more meritorious appeals to be heard. So I would think that this is again a very welcome and positive move that the government has taken to withdraw appeals which really don't merit that attention. You are freeing the court time for more valuable and deserving matters.
So, I was just thinking it, being a devil's advocate here. I have a case which is at the High Court. Wouldn't I be interested in somehow reaching out to this collegium and trying to secure a withdrawal?
No, I don't think that's really what is intended. As I read, I mean, the circular, and this was hidden somewhere because it came in the vacation period in December. There's a much deeper objective to it. This circular, as I read it, is now imposing an obligation on all jurisdictional principal chief commissioners to pull out a list of all the cases that are before appellate forum or high courts or Supreme Court. They have to then make a determination, are there any cases where really there is no substantial question of law arising and appeals need to be withdrawn because they're frivolous in the past. And I think if they stick to the deadline that has been prescribed, the all India deadline is that the final report has to reach to each zonal member of the CBDT by the 15th of April. If this exercise is completed with the intention that has been identified over here, I think in one shot, the government will have a complete snapshot of all forms of tax disputes in the country at a central level. Today, there is no such database that is there. I'll tell you what database is there. We know the total quantum of amounts locked in appeal. We know the number of cases in the appeal, but we really don't know what the issues are.
The qualitative aspects.
Right. This exercise will give you that. Then I think they will be able to make a objective analysis, which are the cases where they need to withdraw the appeal or which are the cases where they need to not contest because there is no question of law involved. So I think this is a very important exercise. In my view, this is transformational. If it succeeds, there are strict guidelines laid down. There are strict deadlines that are laid down for this exercise. And you will see the impact of this current year.
So there's a clear accountability tied to this measure.
Two things I think, like Mukesh said, the government is creating a database because today the commissioner in Delhi does not know that there is a similar matter pending in Mumbai.
Right.
That the government is in appeal in the Bombay High Court on a similar matter. That information is today not available to the Delhi commissioner.
Right.
So that process is separately on in addition to this particular exercise that is being done. Now, in this exercise, to answer your question, while every provision is open to misuse, but here the withdrawal will happen with the permission of the court.
With the permission.
So, if the court is to smell something, I am sure the court will not allow the permission.
So it's not unilateral.
No, it's not unilateral. You will certainly apply to the court to withdraw the appeal, but the court is entitled to look into the reasons why you seek to withdraw.
But do you think this should have been extended down to the tribunal level also, or do you think High Court is sufficient to declog the system?
I think it's also to do with the numbers. You see, the exercise must be manageable.
Okay.
The numbers in the High Court will be much lower than the appeals pending in the tribunal.
Obviously.
And I don't think you have a database where you can find out that what are the appeals that are filed. Suppose you have, I don't know how many commissioner charges in Delhi, and each charge has filed an appeal. Now to assimilate and collate all that data will not be an easy task.
Okay. So there was a clear pragmatic decision that, okay, let's give them a task which they can complete on an effective basis. Very good. Coming to our, another, office memorandum, as I say, which came out, which was on the 43B, disallowance in terms of contribution to welfare funds. Uh, this has been a source of constant litigation all these years, and what is your take
No,
on this?
according to you, even post alum exclusions,
Yeah,
it has been okay.
yeah. So the departments have continued various.
No, on the alum exclusion was in the context of employers' contribution.
That's right.
I remember fighting a case in Delhi High Court where the departmental counsel vehemently, contended that it does not apply to employees' contribution,
Right,
and he was, vociferously seeking to defend the revenues case. But this, I thought, is part of the very process that the government has taken to identify those decisions of the various courts which have been accepted by the department or the department has eventually lost, to send out a circular to the field formation that these tail issues should not be reagitated
Don't fight
any
for
further.
it.
Yeah,
Don't
don't
fight.
don't. So this is probably a
Yeah.
step in that direction, and this circular probably leaves the employees' contribution issue still open.
Yeah, it leaves that open.
Yeah.
But are there, does it bring to your mind certain other aspects which are constantly, despite of there being maybe, very binding or final type of judgments on this, are still continuing to gather, litigation at the lower level? Do you think there are certain other things where the government should step out and accept the
I think
judgment?
one has really not given thought to specific litigation issues, but there will be issues which can, if accepted by the government, can actually put a lid to many matters pending in various forums. So there will certainly be such issues, but the government has taken a step in the right direction to analyze judgments of various courts and to ultimately issue the circular wherever the judgment has been accepted. So I think a very positive move, very positive move.
Yeah, I think the other important part is that the government has acted on a direction that is given by the High Court. So I think really interestingly, I this circular really slipped my attention when I looked at the circular. So the Bombay High Court had said, I mean, it just besides passing strictures, what should the government be doing before they consider filing an appeal under 260A? The Bombay High Court actually undertook a study. It says we directed the registry and also the council appearing to forward a copy of the order to the CBDT. The parties who seek to file the appeals must do so after due application of mind and not raise frivolous. This certainly is expected of the state. The registry has informed us, so this is the Bombay High Court registry, that out of 4,784 appeals from the order of the tribunal filed in this court during the period 1/4/2014 to 2/16, the appeals filed by the revenue are 3,968 and only 816 by the class officers.
Yeah.
So I think it is only after the High Court pointed out these facts and figures and directed that a suitable copy should be forwarded to the CBDT, they have acted on it. I must confess in all candor that in the past, many high courts have passed this kind of strictures. I wonder on how many occasions the Department of Revenue has acted on it. So I would look at this positive and responsive by the government, and they have actually put it out in the CBDT circular. They have quoted what the Bombay High Court has said they've accepted, and then come about with these measures. So I think it's very, very positive.
Again, speaking from practical experience, our friends representing the department in the High Court, when the court, is questioning them that why and how did you file this appeal when you know this is really frivolous, not maintainable, they would say this appeal is given to us at the last minute.
Right.
Despite our giving an opinion to the department that the appeal is not maintainable, it is not fit to be filed, the commissioner would instruct us to go ahead and file the appeal. So on the last day, you have to slip in the appeal in the registry.
Just to safeguard his position.
No, because the commissioner is the appointing authority for the departmental council. So if the commissioner decides that they must appeal, they have necessarily to toe the line.
That's right. So I guess that shows the openness of the department for introspection and to take adverse criticism, which I guess was never before.
Right.
And mostly adverse judgment, in my experience, always came up with a clarificatory amendment in the next budget. But here we see a more amenable approach. Would that
sure.
be a correct observation?
Absolutely. As we say in mythological Hindu, that acceptance and admittance of mistake is 50% resolution of the problem. I
Right.
think we've resolved 50% of the problem.
I'll just give you an issue. The Nalvasan judgment, I don't know if you were aware, which said that if you are assessed on book profit, then any addition alterations in your normal computation would not subject you to penalty.
That's
So
right.
the Delhi High Court gave this ruling, which the Supreme Court approved by dismissing the SLP.
Right.
Now, 2015, if I remember correctly, there's an amendment in law which says that in this kind of situation, penalty can be levied.
Right.
But the circular recently issued says that for the periods prior, withdrawal pending appeals.
That's right.
So this, imparts the necessary clarification to the field formation that for the past, this is not the law.
Right.
Going forward, yes, you can penalize an assessee in this kind of a situation.
Yeah.
So I think this is a very categorical expression of intent by the board, which is extremely welcome.
So, and just to get to a slightly more on the political concept, these are all driven by the tone at the top. So where do you think this philosophy is coming from? Is it the CBDT? Is the finance minister himself?
I think the PM directly.
Absolutely. My feeling is that this is at the highest political level. Whether there's a prime minister or the finance minister or a combination of two, because we all know why there is urgency in seeking a resolution, because this is also one of the reasons why we are not as attractive as an investment destination.
So this is all,
and I also feel until and unless there is political will, this will not happen.
So this is all part of the promise of ease of doing business and increasing transparency, certainty in tax laws.
That's right.
So there is some stock taking happening at
a very senior level. Yes, absolutely. In fact, if you read the circular, it's very clear how the reporting works from the principal commissioner to the zonal member of the CBDT, and I'm sure the unwritten part in the circular from zonal member to chairman, revenue secretary, and finance minister.
Yeah.
It's very clear.
I mean, that makes sense because the bureaucrats have remained the same. So the changes would have happened somewhere.
Well, I think to be fair and balanced, we also need to recognize that bureaucrats acted and behaved because they also were functioning within the constraints of the system. So if no appeal is filed, they have to face the vigilance, they have to face audit, they have to face CAG and CIB and CBI and all kinds of investigative agencies. Now at least there is some empowerment that they have, because at the end of the day all these circulars are binding on the officers, and the circulars couldn't have been worded as clearly and in a crystal manner as they have been done now.
So coming to the last point, we are running out of time. So coming to the one more item, which is the strictures, a 12-point direction issued to assessing officers by the department for towards a non-adversarial tax regime, where they've been asked to avoid issuing non-specific questionnaire, not making high-pitched assessments. Now, as directions, they sound very laudable, but how do I guess here I am asking the question more on a practical side of it. What is your view? Of course, how do you see this evolving?
No, I think at the policy level, again, it's a direction, it's a directive to the assessing officers. But the larger challenge lies in how this is implemented.
Right.
You see, how the field behaves will really shape the fate of assessments. And it is important that the officers are trained to comply with these directives and to be able to make an assessment according to the requirements of law and in accordance with law. I'll give you an example. Most assessing officers send you a cyclo-style questionnaire.
Right.
Half of the queries are actually not applicable to the assessing. because that's a questionnaire that has evolved for some assessees in the charge.
Mhm.
So the easier work to do is to cut and paste that questionnaire and send it to everybody
Right.
who's being assessed in that charge.
Mhm.
Now, this requires orientation. When you actually pick up the file of an assessee, you first need to understand what the assessee does
Mhm.
and how many of those queries in the questionnaire apply to that assessee.
Right.
And similarly, to say that for this assessee, these are the additional queries that will need to be answered. So this will require a change in mindset at the level of the assessing officer. Directives are good, they are policy, they are direction. But the assessing officer must adapt himself to the particular dictate that is being given from the top.
So the AOs must really work hard to before the first questionnaire is sent out. Is that what you see happening?
Clearly, I mean, this office memorandum, which lists down the 12-point dictate,
12 commandments we can
12
call them.
commandments. First of all, the context is that this is a time when the Prime Minister personally sought a review of the functioning of the tax administration, when he had a meeting with the CBDT chairperson, and it's only after that meeting
Mhm.
that the CBDT issued it. As I see this 12 commandment, 6 are nothing but a reiteration of all board circulars
Mhm.
from 2003, including till 2014, which really gives me a feeling that these circulars were there, all well intended, but at the ground level,
Level.
officers were perhaps not adhering to these circular. The second aspect is that there are other 6 points are really intents and dictats, but I think we need to take forward the process of intent and dictat. I'll just read out 2 of them. Number 11 says that any regime where taxpayer grievances are not attended to goes against the grain of the citizens' charter. Okay. However, hence, all the supervisory authorities are directed to ensure that the grievances are disposed of within the specified time. I think they should take this forward. I think what should be made available to people as a part of the citizens' charter would be how many zones, how many grievances were received,
Disposed.
how many were addressed. In my view, it is a fundamental right arising out of the citizens' charter. So I think we should take this forward because that's the only way you can make people accountable.
This is probably like saying that in a company you have the shareholders grievance committee.
That's right.
You should tabulate the result of that committee.
Exactly.
How many complaints received, how many addressed,
So,
they are all
yeah.
stakeholders.
Yeah.
So do you think that these type of statistics should be at least
It should be
published on
made
the
available.
website?
It's absolutely. I'll give you another example. Last one, the issue of summons without adequate caution and due application of mine has caused concern to the board. Supervisory officers should follow this. Now, in my view, they should come out with a manual as a guidance to officer under what circumstances can you issue a summon, under what circumstances can you carry out a survey, what are the rules of conduct. All of these things are there scattered all over.
Mhm.
They need to be now put together as a binder to the officers, and they need to be made to swear like we get sworn in when we take up a job
Right.
or you become a judge or an officer, because I think that's very important. And I think you will still have cases where officers have not followed the spirit. That needs to be dealt with separately. But I think so I think they need to do much more of this kind to be able to gain the confidence of the taxpayers.
I think I only had to say that while this is good in spirit, the orientation of the assessing officer must be to make a judicious assessment. I'll tell you, I was arguing a matter the other day, and I was surprised when the counsel from the other side and the court was equally surprised, said that our assessing officer is a man of ordinary intelligence. He would not know how to read a balance sheet. So the question was whether the notes to accounts in the case of a corporate assessee
Mhm.
should have been read by the assessing officer. He says he would probably not be aware that he had to follow the notes to accounts to really understand what the accounting treatment was, which took us. We were, in fact, the court and I both were shocked at this kind of admission by
Mhm.
the counsel for the department. So if you want to have assessing officers who are either promoted from within or who are
Mhm.
direct IRS professionals, they will need to be oriented to on how to make an assessment. So while these guidelines are good as laying down the framework, in practice they must be implemented. That's the according to me, that's the challenge.
So there has to be a capacity building also to digest all these directives.
I think more than capacity building, I think just to re-emphasize, it's more training and development.
Yeah.
Mhm.
I think they need to completely
Continuing
reorient themselves, how they impart training, how many hours are spent on training? How do you deal, with situations where there is delinquency on part of the officers? How do you build in all of this in the performance measurement system, promotion philosophy? So I think a whole need of, and all of these have been dealt with very, very comprehensively in the part 4 of the Tax Administrative Reforms Commission report. So I think it's much more deeper there, and it can't be addressed with any statute or circular. It has to be again a mindset and putting in place.
But to buttress that, should there be some kind of a, like, a CAG does an audit of, and they're basically focused on where revenue was, missed. Should there be all these softer things also which should be taken into consideration when they're reviewing an SSE's file, that, whether these guidelines, softer guidelines, were also adhered to? Do you think there could be some kind of peer review or some mechanism?
Well, the department has a concept of audit. Maybe they should reorient that and call it a peer review.
And should not be just number driven.
Is to target the leakage of revenue, but
not leakage of taxpayers' service.
See, if you remember the Raja Chalaya committee, and Mukesh will remember this, in 1993, he had said, make the assessing officers accountable.
Well,
I think
Dr. Kelkar repeated it in 2001 in his report.
So I think that is today lacking. While we have these softer guidelines, as you put it, we need to have this accountability in the system.
And this should be perhaps the where the electronic media should be used. And putting things, if the corporate world has to put everything, the grievance committee, how many complaints came, how many things happened. Why shouldn't the focus be put on the government itself?
As part of the e-governance initiative, I think that would be a step in the right direction to put this out on the website.
So one question before I take your views. Can I, as a taxpayer, complain that any part of these directions have not been followed?
These are not statutory. You can possibly, like the department has an ombudsman, you could possibly take it to him as your grievance.
I can take that. But beyond that, it's more of an internal administrative guideline. They are not rights which are being bestowed upon me.
See, the ombudsman experiment, I think, while they have these ombudsman in different places, it's not been a success.
You're being diplomatic about
because he does not have the necessary teeth to be able to implement the decision.
Well, that brings me to this debate that we had at the recently concluded IFA Congress in Basel. One of the scientific topics was taxpayer rights. So in many countries, as an integral part of the taxpayer citizens charter, taxpayers' rights are clearly classified. Today, what I get is my right to appeal, which is me approaching the judiciary. I don't think we are talking about that.
At my cost.
At my cost. What are my rights? If my confidential information is leaked out, can I drag the Union of India to pay me damages? If I am subjected to harassment, or I am subjected to mental torture at the time of search and seizure operations or survey operations, if I'm subjected to pay tax and after many years I get it refund, is that 6% interest good enough to compensate me? Clearly not. And I think
we not even take the care of the cost of litigation.
Absolutely. My view is that our Citizens Charter, which the last version is 2014, has to incorporate taxpayer rights. Because my right is not just my right to file a writ petition or my right to appeal under 260A. My right is far beyond that. And it has to come more from intent rather than from a statute. And hence it is important to reorient our Citizens Charter.
If they start accepting this as a taxpayer as a consumer, then probably it opens up a whole forum. Otherwise,
but for viewers who are interested in this subject, taxpayer rights, they should read the Kayer series of 2015 Basel Congress. It's some beautiful, very well written branch reports by many countries on what taxpayer rights are in various countries.
So I would request IFA, because it's their publication, to send a book, the whole collection to the department, because when you're opening up for your soul searching, I think this is one of the main areas where as a taxpayer, you are the meek.
Correct.
You are the
Yeah.
weak.
Correct.
And the more you are strengthened, I guess, the better it will be for
I'll
everyone.
give you one more example. I know we have an overwhelming response on APAs, and this is something that we keep on debating with the APA authorities. Taxpayers who give confidential business information and strategy to APA, they want protection that this will be treated confidential.
Yeah.
It's an integral part of taxpayer rights. We haven't made any progress, but I think those are precisely the issues that we have to deal with to gain confidence of taxpayers.
Yeah, even in the normal transfer pricing
Exactly.
thing,
Exactly.
they ask you for whole sorts of information.
Yeah. There is a survey operation with a taxpayer, large taxpayer. Next thing you see is all the business channels are running a ticker. There's a search and seizure operation. There is raid in this office. I think it, large corporations, listed companies are extremely concerned about reputational risks arising out of it. And if you have a strong taxpayer rights, and if you have that integrated in the citizens charter, I think people will be much more responsible before giving away that news.
So I guess to sum it up, a lot of new things have
Right.
been done. All of them are positive, but it just makes us hungry for more. Is that what you would sum it
I
up
would
as?
think we would look ahead to the budget 2016 also for some far-reaching and changes in the tax
So
legislation.
is there some buzz on that going around? If I could just...
Difficult to hazard a guess, but I think certainly you can expect some changes in the office.
My view is that a large part of the tax reforms agenda will be driven outside the non-legislative part of the business. So these are all administrative changes that we talked about today. You will always have those big items, reduction in corporate tax rates, so on and so forth, tweaking that will happen in the budget. But I think many of the transformational changes will take place through subordinate legislation.
But the seriousness is clear.
Yeah.
I guess
Seriousness is very
clear.
clear.
Yes.
And there's a lot of catch up to be done.
So that itself would be a comfort to many of your clients,
Sure.
I guess. That
Sure.
there is an openness, there is an intent.
Right.
Good.
Well, there's too much comfort for some of our clients because they read the newspaper and said that if XYZ case got settled out of court and the government intervened, why can't our case be?
Yeah, why can't you get my case also settled
right.
out of court? I guess challenges will never leave.
So that's where the over expectation part comes in.
Always, under promise and over deliver. I guess that's the hallmark. So, with your kind permission, I would like to bring the webcast to a close. It's been definitely very insightful, and we were not able to cover a couple of topics, but don't worry, we'll take that up in our next webcast. Thank you very much, Ajay. Thank you very much, Mukesh, and have a great weekend.
Thank you.
Thank you.
Thank you.